Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
All right, y'all. Welcome in and welcome back to another YouTube video. I am your host, Document Tingz, and we are here to get into some court updates. Now, this is something that came out yesterday, and we're going to get into it now. As you can see by the title, Daystar Peterson, also known as Tory Lanez versus MeganPete. Now, this is pertaining to MeganPete versus Milagro Elizabeth Cooper's case. Now, as y'all know, the case has been filed in Florida. However, Tory Lanez is incarcerated in California. So this is from the Central District of California. Tory Lanez filed this as a movant. Now, movant is a person who applies to or petitions a court or judge for a ruling in his or her favor. Now, before we actually get started, let's make sure we have our copyright disclaimer under Section 107 at the bottom, as y'all can see scrolling there. This is fair use. I am not a paralegal. I am not an attorney, and I am not a judge. I am simply saying that, hey, I know how to read. And without further ado, let's go ahead and get started and get into the actual court documents. So, as you can see here, movant Daystar Peterson by counsel respectfully moves for a protective order under Federal Rule of Civil Procedure 26C. Mr. Peterson, an incarcerated non-party in Pete versus Cooper, and as y'all can see there is the court case number, faces undue burden, prejudice to his ongoing criminal appeal, and constitutional risks if compelled to provide further deposition testimony. Relief is warranted to ensure compliance with the federal rules to protect non-parties and to safeguard Mr. Peterson's rights. Okay, so let's get into a little background here. In Pete versus Cooper, respondent MeganPete seeks to compel discovery from Mr. Peterson, alleging he compensated a co-defendant to defame her. Mr. Peterson was deposed as a non-party on April the 9th of 2025 and again appeared on September the 15th of 2025 under objection. Unlike other non-parties, Mr. Peterson remains incarcerated in California while appealing his conviction in People versus Peterson case. As y'all know, as you can see here, BA 490599. That is the case. If you go to California's website, go to appellate, and you can type that in. You can get the information there. All right, so let's continue. His direct appeal remains pending as of September 2025, following habeas denials in August of 2025. At the September the 15th, 2025 hearing, Pete versus Cooper, docket entry 143. Mr. Peterson objected to further compelled deposition, underscoring the need for intervention by this court, the District of Compliance. On April the 9th of 2025, Mr. Peterson was deposed as a non-party in Pete versus Cooper. At this time, he had a limited appearance attorney, Michael Hayden from Unite the People, Inc., who was also the attorney of record for Mrs. Cooper. At this case, no, it says as this case is in the Southern District of Florida, Mr. Hayden was appearing pro hac vice through local counsel. As shown in the email attached hereto as Exhibit 1. Now, I will do separate videos of these exhibits. Now, some of these exhibits you may have seen already. However, we're going to go over them in separate videos, so you'll see them slowly get attached to this one. That way, y'all can get into it, okay? And as always, I will have the court documents in the description box below so that you can get into it, okay? So anyway, let's continue. and incorporated as if set forth fully herein verbatim. They only represented Mr. Peterson for this deposition. In Pete versus Cooper, other non-parties have been deposed and treated differently. Specifically, Mr. Caesar McDowell was not cooperative in his deposition, and neither was Mr. Peterson, nor was Mr. Livingston Allen. Regarding Mr. McDowell and Mr. Peterson, Ms. Pete filed her orders to show cause. Order to show cause against Mr. McDowell and Mr. Peterson are attached hereto as Exhibit 2 and incorporated as if set forth fully herein verbatim. Mr. Allen is a resident of the state of New Jersey. As such, on September the 16th, 2025, Ms. Pete filed her motion to compel in the United States District Court, District of New Jersey. Despite both Mr. Peterson and Mr. McDowell being present in the state of California, similar motions to compel were not filed. Furthermore, only Mr. McDowell's order to show cause was denied. Orders granting and denying orders to show cause is attached hereto as Exhibit 3 and incorporated as if set forth fully herein verbatim. Now, we're going to take a slight pause. Now, I did go over this particular court document that he is mentioning as Exhibit 3. However, again, I will create separate videos that way that y'all can see the actual exhibit. Okay, so anyway, let's continue. The court found that plaintiff, Ms. Pete, must comply with the Federal Rules of Civil Procedure 37 and Rule 45 in seeking relief regarding non-party discovery. Specifically, it was found that Federal R. Civ. P. 37A2 applies when compelling discovery from a non-party and must be made in the court where the discovery is or will be taken. Y'all see that? Mr. Peterson is currently incarcerated at the California Institute for Men. Therefore, the deposition would take place in the state of California within the Central District Court's jurisdiction. The show cause was also denied due to Federal R. Civ. P. 45G, which mandates that contempt efforts are borough within the district where compliance is required. I may have butchered that word right there. Broke, bro, or broke, however you say it. Anyway, let's continue. On September the 15th, 2025, Mr. Peterson appeared with counsel of record and continued his deposition with the approval of the magistrate in order to determine whether Ms. Pete must compel his testimony through the Central District of California. Mr. Peterson's attorney urged that Mr. Peterson in herself did not have the mandatory 10-day notice in order to prepare and were not properly compelled to give said deposition. Magistrate Reed determined that Mr. Peterson was being treated differently from Mr. McDowell due to Mr. Peterson's deposition being continued through the order to show cause, yet time to file this instant motion was still given. Mr. Peterson prays this honorable court will find that he should be treated as a non-party, the same as other non-parties in Cooper. All right. Legal standard. A party seeking a protective order bears the burden of establishing good cause. And then y'all see they quoted a particular court case. Courts have broad discretion to limit discovery when the burden outweighs the benefit. And then that's another quote from a different court case. Non-parties receive heightened protection. Another court case, as y'all can see, that was referenced. Discovery must be narrowly tailored and non-duplicative. And that is another quote. The Central District of California routinely applies these principles. Another quote. All right, y'all can see there. So we're going to scroll on through. We're going to start right here. Rule 45 mandates that courts quash or modify subpoenas imposing undue burden, enforceable only in the district of compliance. And then that's another quote. Cross-shifting also protects non-parties, another quote. And then it says, finally, prisoner depositions require court leave. And then it gives Fed R. Civ. P. 30A2B. Safeguards must be imposed to prevent undue prejudice. And then that is another court case. So here is the actual argument. As Mr. Peterson is a non-party and then that's a quote from Fed RCiv P 37A, does not apply to him. Mr. Peterson is a non-party entitled to heightened protections. And then that is a quote there, premium service 511 F 2D at 229. Ms. P bypassed party discovery, violating Moon 232 FRD at 637, and now seeks burdensome testimony from an incarcerated non-party whose direct appeal is still pending. And then that is a quote from another case there. The court confirmed that depositions of non-parties require adherence to the requirements of subpoena and appropriate notice, and stressed that a motion to compel compliance or further testimony must proceed under Rule 45 rather than Rule 37A. Since Rule 37 applies primarily to parties, the decision reinforces that treating non-parties differently or applying shortcuts not authorized by the rules is grounds for judicial intervention to protect the non-party witness. The court and y'all see that, Blackman, emphasized that motions to compel non-party depositions must comply with Rule 45 and that non-parties are entitled to protections to prevent being subject to unduly burdensome or unauthorized discovery procedures. Rule 45 requires enforcement only in the District of Compliance. And then it says DJO 295 FRD at 497. Because Mr. Peterson is incarcerated in California, the Southern District of Florida lacks jurisdiction. This court alone may act. Compelled testimony risks infringing Mr. Peterson's Fifth Amendment rights. This is some tea, y'all. We got some tea right here. Y'all pause. We're going to pause real quick. This is some tea. Compelled testimony risks infringing Mr. Peterson's Fifth, as y'all can see there, amendments. Right. Y'all see that, don't you? Now, pause. This is a question that I have. Is he doing the Fifth Amendment? Is he invoking the Fifth Amendment right? That's the question that I have. Anyway, let's continue. Prejudice to the criminal matter. Well, let me rewind back. Let's rewind back. There's there's 4 key points here, as y'all can see. Key point 1, prejudice to the criminal matter. Key point 2, burden on civil courts. Key point 3, the public interest. And 4, y'all can see there. So I wonder, what is this? That's a question that I have. Is he invoking the Fifth Amendment? But anyway, let's continue. Mr. Peterson's risk for prejudice is great, as the opinion for his direct appeal will be delivered by November 16th, 2025 at the latest. There is minimum delay, so a slight burden on the civil court, as Mr. Peterson is merely a non-party, and discovery has been ongoing and extended in Pete versus Cooper. The public interests favor Mr. Peterson, as there is favor to protect due process over duplicative civil discovery. Furthermore, as importantly, I'm about to butcher that word, and I sure don't want to butcher that word. Y'all hold on one second. We're going to make sure we get this word correct. Equities. Okay. So the equities weigh against compelling an incarcerated non-party. Relief requested. Mr. Peterson respectfully requests that this court grant a protective order quashing further deposition absent proper Rule 45 compliance in this district, or in the alternative, limit any deposition to written questions under Rule 31, shift costs to Ms. Pete as averred supra, impose Rule 30 safeguards tailored to Mr. Peterson's incarceration and pending appeal, and stay deposition pending resolution of his direct appeal under Keating. Conclusion. For the ongoing reasons, Mr. Peterson respectfully requests that the court grant his motion for protective order, bearing improper non-party deposition, or alternatively, limiting discovery consent with the federal rules. Ninth Circuit proceeded in constitutional protections. This is submitted this 24th day of September of 2025. As I mentioned, this was done yesterday. And this is just a little information here. Okay. And that was it. Quick, huh? All right. So if you like what you see here, like, share, subscribe. I am so happy and I'm so proud to announce, hey, I've hit over 500 followers. How about that? How about that? So I appreciate y'all for subscribing. Again, there is a lot of news going on pertaining to this case and its ongoing. Trial starts November the 17th. This has nothing to do with Tory Lanez. However, this is interesting here. So nonetheless, y'all know what to do. Hit the like button, share, subscribe. It is all free. And if you like what you see here, share it with a friend. Bring them on over. Also, as always, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. Y'all have a good one.